Everybody stand for the pledge, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Clerk, take the roll.
Mayor O'Connor.
Here.
Morissette.
Here.
Wakefield.
Here.
Knudsen. Here. Kennedy.
Here.
Bruck.
Here.
Hall.
Here.
All right, first thing up are comments or suggestions from citizens present. This is your opportunity as a resident of the city of Hudson to comment on anything, any issue that you'd like that is not on tonight's agenda. If you do have a comment, please come to the podium and the mic, introduce yourself and where you live, and try to keep your comments brief, and please try not to repeat other people's comments. So, does anybody have a comment? Any comments? Any comments? Any comments? Hearing none, we'll close that portion of the agenda. Consent agenda.
Approve the meeting minutes from September 5th, 2023 regular council meeting. Approve claims in the amount of $717,710.84. Approve 3rd Street Halloween Spooktacular, and approve the certificate of compliance for Latin services at 2521 Hanley Road, Suites 300 and 600, and I don't know how to pronounce that.
Move to approve.
Second.
Got a motion and a second to approve the consent agenda. Roll call.
Morissette.
Yes.
Wakefield.
Yes.
Knudsen.
Yes.
Kennedy.
Yes.
Bruck.
Yes.
Hall.
Yes.
Motion is approved. Consent agenda is approved. Ordinance 11-23 to rewrite Chapter 255-17.1 through 255-17.10 in the City of Hudson zoning code.
So obviously we missed a meeting in between. We had the first reading 2 meetings ago of this downtown overlay district. I do have Bob Colson here with Cedar Corp to present and answer any questions about the downtown overlay district and its relationship with NR 118. Bob, if you want to come up, I'm sure there will be questions. I want to be very, very clear. Obviously, one thing that's a little different with this is we have both the downtown overlay district, which encompasses effectively all of downtown. And we also have NR 118, which is effectively everything west, on the west side of 2nd Street, that we also deal with. NR 118, the city will have its own ordinance that it will eventually adopt as part of our process that we're working through with Cedar Corp. That is currently being looked at by the DNR. The DNR needs time to review that ordinance, and it's anywhere from, 60 to 90 days, Bob, is what they have informed us of. So my guess is it'll take all of the 90 days, and that we're probably, 60 days into that at this point?
Pretty close, yes.
Yeah, so we'll have that ordinance too. So I think the conversation the council needs to have, or I would recommend that the council has, is hear about the NR 118 component and the history of that statute and how that came to be, but also understand that it is okay that we have this draft ordinance put together for the downtown overlay, and that if we need to, we can, if it makes the council more comfortable, effectively approve both of those at the same time, both the city ordinance for NR 118 or our chapter on that or our section on that, as well as the downtown overlay, if that makes sense. I'm trying not to make this any more confusing as it is, because it is very confusing. NR 118 is probably one of the more challenging statutes that we have to deal with and enforce. It's our responsibility to enforce that. That being said, there's no pressure, or, if the council doesn't approve the second reading, we want to postpone for, the downtown or for the NR 118 ordinance, we can certainly do that. We'll continue operating as we always have. We've adopted NR 118 whole cloth, so we just adopt state statute. It's not perfect. The state isn't crazy about it. But, if it's more palatable for the council to address them both at the same time, that's certainly okay.
So you're okay with first read on this?
Oh, absolutely, yeah. Okay. Yep, no,
We had the first read on this.
Staff is very
On
comfortable.
this one?
Yeah, we
Yeah,
did.
we did.
Yep, and Plan Commission reviewed it and recommended approval of it too. Staff is very comfortable with this. We think it streamlines things. It doesn't make anything easier, doesn't make anything harder. I think, you know, like I said, professionally, staff is good with this. But ultimately, from a policy standpoint, the council needs to weigh on it. You know, if you want to address them both at the same time, I think that be okay too.
Yeah, and just to clarify, your downtown overlay district ordinances take care of your downtown district. NR 118 takes care of the St. Croix Riverway district.
Half of downtown overlay effectively.
Which is, right, and so you have overlapping jurisdictional regulations, right? And typically NR 118 is looking at really protecting the riverway, and your overlay is looking at protecting and preserving your downtown district. So as you read through and you look at what's happening with NR 118 and what's happening with your downtown overlay, it's important to think in those terms because you really need to harmonize those two. And that can be a challenge sometimes, particularly when you have redevelopment downtown, but you also have NR 118 that is seeking to preserve and protect the Riverway District. So I think I can safely say from a staff perspective, we are more than fine with the council taking as much time as it needs to really kind of think through these various issues and regulations and how you want them to work together, because they're very important in the way that they do work together.
So I have a question for, I guess, we'll start with Mike. So the NR 118, I mean, our whole goal of the rewrite was to make it easier to find the information that applied to, you know, your question, basically. Will the NR 18 be put on after this or sprinkled within this? I mean, I guess I'm trying to see, without knowing what that is, and then knowing exactly what we're looking at tonight, will it change this? Will it be an add-on at the bottom? Will it be, I don't know if I'm making myself clear, but
No,
I don't know what that's gonna affect what's written here.
Like, are we gonna have conflicting code sections?
Yeah, and I assume
Bring
that's our goal
forward.
not to,
Correct. No.
but with only seeing one of the pieces of paper, let's say, and not knowing exactly how that fits together.
I can tell you that that's not gonna happen, but obviously you haven't seen the other one either.
Right.
So, you know, Bob, you would confirm that, but it's.
Yeah, if I might. So currently in your code, as Mike said, that you guys have acknowledged NR 118, which is required by statutes, whole cloth, everything in there. It's just a note that says NR 118 applies, and then it's up to the applicant and then to the city to kind of wade through and make sure that those provisions are there. That's been around for decades. That language, it's not changing. What's changing is that we're just removing that NR 118, that one little sentence out of the ordinance, and writing the section that meets the code. And adopting that. So
That means the statute.
yes.
Right, okay.
So it's nothing is really changing other than this is being fleshed out so a person can read it, and it applies, the pieces that only apply to the city are what's going to be in that ordinance.
And I think, and to expand upon that, we cannot be less restrictive than the state statute.
Correct.
We can be as or more.
Correct.
So, you know, if we said, you know, whatever, DNR, we want to build a 80-story skyscraper or whatever, we can't do that.
Right.
You know, we have to be more restrictive. You know, there are, you know, other ideas that, you know, we could look at. You know, I know I have communicated with a lot of the council members and plan commissioners. I think there's an issue with our rear yard setback requirement being at 25 feet in an urban environment. I think there is some challenges with, you know, some other flexibility in terms of, well, not flexibility, but just the administrative component of if somebody wants to put a sign on their building and it meets all the code, why can't that be done administratively by staff? You know, doesn't it need to go to plan commission and then council, or, you know, certificate of design review, which is just plan commission? All those things, kind of play into this, but, you know, I think ultimately, I guess from a staff standpoint is, we're trying to come to, you know, put together a code that is easy for people to understand for the layperson, or as easy as it can, we can try to make it
Yeah.
to the layperson.
Within reason.
Right? Because, you know, we've had nothing but issues, at least in my time, and I know before my time, kind of wrestling and grappling with.
Well, and building on that, right now, if you want to do anything in the NR 118 area, it happens to be in the downtown district, you go to the code and you look at the downtown overlay district ordinances and requirements, you can figure those out. And then you look at it and say, oh, okay, well, I'm in the lower scenic St. Croix Riverway district, and it says, well, we've adopted NR 118. Well, so then you got to get out the code, and you got to go to the statute, and then you've got to try to apply the statute to the city. It's just difficult. It's,
Yeah,
it's
right.
not user-friendly,
It's a
so.
little, it's unwieldy. It's
Yep.
just, it's difficult for everybody, developers, staff, everyone.
So are you saying, you mentioned a window of time that DNR is evaluating. Have you already submitted
Yes.
the Riverway?
Yes, it's been there,
Proposal.
as Mike said, it's probably been there, coming up on 60 days, so it's been.
Has the Plan Commission discussed that yet?
No,
Or
we'll
no,
bring it
you're
to them
you're taking it
once-
to DNR first and then Plan
Yep.
Commission?
Yes, we wanted to get the state's comments and then address those and then bring that to the
Sure,
council.
thank you. I was wondering, I had not noticed
No,
them
we haven't
discussing it
brought it
yet.
yet
but
for-
That's your process, thank you.
And then we'll have to also give the DNR at least 30-day notice to, once we have the public hearing on the adoption of said ordinance, and we probably won't get comment from that back until day 29.
Can't blame me for picking on the DNR this time.
I'm not picking on it. Just saying, you probably won't.
The process.
It's the process. This is what it is. They're busy. We all are.
Sure.
If I may, at the public hearing, a resident brought forward the idea of, on the appeal process, which is on page 13 of the proposed ordinance, that we add in a spot for the community members, or for residents and for business owners. And I had asked that we would consider adding that so that they would have their own due process and their own opportunity to bring forward an appeal within a certain number of feet from the proposed development. I'm not seeing that being added in here, and I'm hoping that's something we can talk about. Adding a component where residents and business owners within a certain number of feet could also appeal a decision if they weren't happy or satisfied.
So, I do recall that comment last time, and we didn't take it as a directive, and maybe that was my misunderstanding on my part. I don't know, and I guess maybe this is a question maybe for council. I don't know that it's limited only to the downtown that could come to the council and say, hey, this is wrong. Can we appeal this? I guess I think
I was thinking this was just about the downtown overlay, so that's why I was thinking it was related just to this one specifically. I affirm that decision, that statement you just made, but I'm not certain about my fellow council members.
No, I like that idea too.
You know, I don't have an issue with that. I don't see any problem with that, but wouldn't they have standing for appeal anyway?
Well, it depends.
Wouldn't anybody in the city have standing to appeal?
Certiorari review.
It depends on what your process is. This code provision sets up a process, an inner city process for appeal. The certiorari piece of this is a direct appeal to the circuit court. If an aggrieved party, anybody who is aggrieved by a decision, wants to have the court review a decision, certainly there are opportunities for that. But as Bob said, it's probably a little more, it's a broader discussion when you talk about building process. Do we want to build a process just for the downtown overlay district? Do we want to think about having more a process that's broader with respect to land use decisions and permitting decisions that are made throughout the city? Certainly something that we can think about and give some feedback after we take a look at it.
We can look at it more certainly, but I do struggle with a decision being made and then somebody comes back and, their neighbor says, I don't like that color green on your sign. And one person that happens to be, this could be just an unending cycle of nothing happening. And I think, from staff standpoint and ultimately as a council, I think we want to be open to people doing projects downtown, redeveloping, continuing to make and improve upon our downtown. I do struggle with, somebody does a project that gets approved and then 10 days later, you're telling a developer, well, Joe next door just appealed the decision the council made and now we're going back in front of planning commission and council or whatever that process is. I don't know that's the best way to approach it. I'm
Needs to
not
be
saying that there shouldn't be a,
narrowly
if you were to
tailored
do something, it
to-
should be fairly narrowly focused. Nick, I think you would probably agree. Bob, I think I want to be very cautious in that because that does tell people that are willing to invest in the downtown, that tells them that, it's not how you kind of want to offer, open your front door to people, that if all of a sudden my neighbor wants to complain or, appeal a decision just because I don't like this restaurant or this retail shop or this whatever next door to them, to appeal that decision.
But different processes have different appellate rights as well.
Right.
For example, if somebody applies for a variance and their neighbor doesn't like the variance that's granted, then the neighbor has the right to pursue an appeal.
Right.
Which we have that going on in the city right now. So there's that process. There are probably some things that we want to be more administrative in nature or more efficient in nature. And if folks want to come to the Plan Commission and voice their concern about a particular application, they have that right. But I think Mike is right in his comments that we want to think about how we provide those that are applying. And it's not just developers, it's downtown city businesses that are already here that may need approvals as well. We want to provide for an efficient process that has a natural end to it as well. So, it's good conversation, and we can certainly think about it. But just because that particular right isn't in here doesn't mean that there aren't other appeal rights for big decisions that get made on conditional use permits or variances, or other approvals that the council grants.
But
We can look at it. If you're gonna make an investment in a property downtown, but you know that whatever decision's gonna be made for whatever you do, then your neighbor just complains and we're gonna go through a whole other process. That uncertainty is concerning, and it probably would deter people from doing projects in our downtown. Not probably, it would, because, people want to walk into something where, hey, I'm meeting code, I'm doing exactly what your code is prescribing. There's no real reason to deny this application, but all of a sudden, your neighbor complains, now we've got a problem. We're going through that process. So if we can narrowly focus it, and we can look at it from a, more of a legal standpoint, I get what you're arriving at, and believe me, myself more than anyone that has had to deal with it, many downtown development projects in this town, it's hard because you know what? There's always going to be somebody that doesn't like it. There's always going to be a lot of people that don't like it, and you're going to hear from them. And sometimes it's positive, and sometimes the council's like, no, this is a great project, but there's always going to be some, and it's hard. And I know, Councilmember Brook, you deal with that too. It's just, I think you're trying to protect staff and the city and your residents, and I believe in that. It's just how do we...
I am in favor of there being tight parameters to it. I just want to make sure that our community members and our existing business members have the same due process that developers have.
Right.
That there's the same treatment and not where one has preferential treatment to the other. And in this particular case, when we don't have that in there, it feels like there's perhaps
Okay.
greater opportunities for the developers than the existing business owners and the neighbors. But again, I'm in favor of tight parameters.
Well, I
One thing,
have a
if I might,
comment.
oh, I'm sorry, go
No,
ahead.
go ahead.
It's important to understand that the overlay pretty much deals with just the certificate of design review. The underlying zoning is still in play. There's a lot of rules that aren't even in here that are still in play because the underlying zoning is there. This is just an overlay that deals with just this particular issue, just the downtown overlay and what it takes to come into the downtown. So all the other stuff is still in play, but it's in the background, and well, we can talk about that a little bit, but it's an overlay, so the underlying zoning is still there, and some of that stuff may show up in the underlying zoning, not here, but doesn't mean that it's not applicable.
And I don't believe it's there now. And so perhaps it's in the next iteration of what you're working on.
I think there is an appeal process in the zoning. If not, we will be addressing that with the rewrite, so.
Well, I had a question about a section that's been removed, and this might actually play into a little bit of what Councilmember Book was saying, that we used to have a design review committee that was part of a section, let's see here, 255-17.4. There was a design review committee. Was that ever effective? Has it just kind of gone by the wayside?
Effectively, that's the Plan Commission for Certificate of Design Review.
Okay, all right, thank you, but did it have a different name before, or was there actually a group of people?
When they established the original ordinance in 2007, it was
Okay.
never established until, I don't want to quote years because I can't.
But so there was never like a separate group of business owners,
There was some appointed
downtown
for
residents?
some issues, and then ultimately it went to the Plan Commission for Certificate of Design Review, just to have it just
So
under that. group.
there wasn't ever really a separate, like,
Never-
citizens
never
committee?
met. No.
Never
Nobody
s-
wanted to do it.
Right, thank you. I wanted to clarify that because I see that section was removed, and I didn't know if it had ever been utilized or had been effective, but you feel like streamlining it to just have one body, the Plan Commission.
Should be Plan Commission, yeah.
Take care of it.
My recommendation, yeah.
Mhm,
that's
okay,
the rule.
thank you for explaining that.
So I had a question back to Sarah, your point, and I totally respect the idea of when local businesses or residents or whatever, when their voice gets heard on these new developments or redoing of an old building or brand new building or whatever. So, I mean, that's what we're here for, is to listen to that. But I've always seen this process sort of a funnel. We have the the public meetings, the neighborhood meetings where people can talk with the developer. It goes to the Planning Commission, it gets kicked around here. Sort of a funnel down to, where ultimately the city council decides whether it's yay or nay on it, right? And then you're saying the citizens could come back and say, well, we didn't like the decision that the city council made, right? So I'm just wondering where it would go from there. So then we rewind and have another hearing on it? I mean, I'm just trying to figure out, like you said, if a developer knew that no matter what we approve at one meeting could get kicked out in 30 days from then, if that was our timing. So I'm trying to follow how that process would work. If someone said, wait a second, I don't like what you guys approved, then what happens? Then do we go back to square one again? I guess is my question.
Well, I would,
How would that decision ever get made?
so I would think it'd be a similar appeal process that the developers would be following.
Okay,
So if that process is afforded to the developers, should not that same process be given to our community members, our
And
taxpayers?
I think it is, I guess that's where I'm a little confused, where the process isn't afforded to our existing businesses or.
Well, it certainly isn't reflected in writing.
Okay.
And so maybe it's not clear. So, and if there is a process, I personally, in my time here, haven't seen anything like that. Perhaps other people have prior to me.
I have an idea. Maybe if we put in, Nick, you can guide me on this if you would. Maybe we just talk about, we reference the fact that they have that judicial, residents that are aggrieved by a situation do have the ability to, you can put it in code, court review of a decision if they feel aggrieved by it.
Well, that might be one way to do it. I mean, when you think about your underlying code, and I was just kind of looking at the appellate process in your code, for any decisions that get made by the zoning administrator, there is the right to appeal to your Board of Appeals. Right? So just not thinking about this ordinance for a second, but if the zoning administrator makes a decision, or the planner, the building inspector, your Board of Appeals is authorized jurisdictionally to hear and decide appeals where it is alleged that there's an error in any order, requirement, decision, or determination by the building inspector, the planning, or the zoning administrator.
And we've seen that in the past.
Yeah, you've seen that.
Yep.
And then with respect to conditional use permits, they originate at the plan commission, but ultimately the council makes a determination on conditional use permits. So you have a public hearing where folks are permitted to offer their testimony either in support or objection, and then it comes to the council where, presumably they can comment again if they're in contact with their council members. To Bob's point, what we're talking about with this ordinance is that it's just an overlay for the downtown district itself. And if an applicant applies for a certificate and they don't get it, they have the right to resubmit and ask why and present additional evidence. Could you have a process where you allow those within proximity to appeal? You could, and you can. I think we want to think about that, because if I want to do something to my law firm building down here, which is in the downtown district, that would require a certificate, and I have neighbors around me that don't like what I want to do, but what I want to do is permitted by the code, do you want to extend that appellate authority to the neighbors? Maybe you do, maybe you don't. It's a question and a matter of policy. But I hear the word developer thrown around here, or used in this discussion. This isn't just for developers, right? I mean, I think it's everything that goes on in the downtown district where somebody would be required to get a certificate, and that's going to include those that are here currently that want to do things with their buildings as well. So it's a great discussion, and I think we want to think about it, but it's not as though there aren't appellate procedures already in place for the larger approvals that need to be granted at this point. And again, this is not a final reading. There's not going to be action on this ordinance tonight, so we can think about it as staff and take the comments into account.
One other thing, if I might, is that we entered into the process knowing that the downtown overlay was one of the districts that really needed to be worked on ASAP. And knowing that the entire process of amending the entire ordinance is pretty lengthy, and so we were focusing on the downtown as a first shot across the bow. And as we spoke to staff about this, and it's probably worth bringing up again with the council, there's an opportunity, to test run some of this, because when we come down to the point where we're going to be adopting, the rewrite, the overlay district, there's going to be some tweaks because there are sign ordinances and things that are still out there. That's going to be rewritten to comply. And so if there were issues that came up, there's a chance to kind of test run this and kind of tweak it when it comes time for the actual, the entire ordinance which roll into this. I don't anticipate that the downtown overlay is going to be substantially different, other than there are sections that we didn't rewrite because they're cross-referenced in here right now. Otherwise, we'd have to rewrite those sections as well. So there's some cross-referencing, but it will all get rewritten and rolled into one.
I think, Bob, that's a good point. Is there really any, when you look at the changes or in this new ordinance, what substantive changes are there from what we currently deal with right now? I think that's a question that, a lot of people have. Like, okay, we're changing this, and people are like, is it easier for developers? Is it harder for developers? Is it the same? And, I would contend that it's pretty much the same ordinance in all reality, written for all intents and purposes.
It does put a lot more onus on the applicant than in the past, just to convince the city that what they want to do fits with the purpose statement. And the purpose statement is a very clear purpose statement specifically for the downtown with some very, very specific ideals that things would get weighed against. And so I think that's important also to kind of recognize that everything would get brought back and supposedly weighed against that purpose statement in terms of making a decision, yay or nay.
Well, if I could comment on that, I know I've heard you say those same sort of instructions to the Plan Commission. And first of all, one thing is when we vote, we're making an ordinance. So changing the ordinance later, unless I don't understand the procedural, are we going to adopt piecemeal parts of the ordinance and then do one big vote at the end again? Or how will that be handled? Because whenever we make an ordinance, I always feel like it's a significant change, we have first reading, second reading, to discuss it. And so that is my one hesitation about, and I realize that staff directed you, and I appreciate your focus. I think it was correct to focus on the downtown area first in your rewrite, in your approach. So that's good, that's important. I know the Plan Commission seconded that and instructed you to do so. I think that's just a little bit of my hesitation that our vote, our decision, feels like it carries more weight because it locks it into an ordinance versus the Plan Commission saying, yeah, that looks pretty good, keep moving on, if you can see what I mean. So I don't want to feel like I'm putting the brakes on your effort, but that's the thought process in my mind is, should we be voting this in as an ordinance if we're not absolutely positive that we're done with this part?
The comprehensive rewrite, except for this piece, is not going to come before the council piecemeal. It's going to be a big document, and it's going to take a lot of. It may come to you as a complete document. You may choose to discuss it by section, but we're not proposing that we're going to write a section, bring it to the council, and adopt a section and move ahead. This is the only piece that we said we would do that with, and this piece, except for the cross references back to the existing ordinance, because those will change maybe just where they live, just the actual address of it. The text may not change, and so. This ordinance, is it 100%? I don't know that an ordinance is ever 100% because there's always some things. But I would think that what we're proposing for the council to do is on the second reading or whenever you do it is to approve, if you're comfortable, to approve this. This will be the ordinance. That what people will be bringing in to the city for applications, for review, for approval, for decisions will be based off of this ordinance. Period. And so it's not that this is something that's not finished and we're moving on. It's as finished as we can get it. It's not a standalone.
Yes,
but it is a section, and it's not unusual that cities will amend a chapter of their ordinance, and then that may then in a month or two precipitate other changes. That's kind of what we're doing here. So I guess I can't tell you that it's 100%.
Thanks for the feedback.
Well, nothing's ever final if the council wants to make a change.
Well, now with zoning, it doesn't seem
We have
like.
that prerogative.
My only other comment about, I understand as a professional and someone who works in the field, I said this to Mike Johnson earlier in the discussion, I can see you're trying to take out some of the verbiage and wording like, is it Italianate, is it, ornate, whatever the descriptors were. But for someone who's not schooled as much in architecture, and I know our Plan Commission members are very experienced and they have the guidance of our professional staff, but it feels removing, those almost felt like guardrails to me, that, it has to fit in this style. And I know you're saying that it's going to be harder or puts the onus on the applicant to prove themselves. It still takes a Plan Commission team that's willing to look closely at everything and ask the hard questions and ask for a new drawing or a new schematic if they don't like the facade or something. to still interpret it. It still has to, the rubber has to hit the road.
Yeah, so, I don't disagree. I mean, this is not easy stuff, necessarily. I mean, somebody coming into your downtown, and every time that I drive through the downtown on the way to a meeting, I'm always thinking about this ordinance and some of the things that happen. And the downtown from one end to the other, they are different. They are really different and unique. And so, and this may not speak to what you're talking about, but there was a comment last time we were here about, well, you know, you're making it too easy and that there should be hard and fast rules. And, you know, it is so unique that a one-size-fits-all ordinance probably would not do you justice. I've experienced those in the past, and they're narrowly focused, and they don't take into account the unique aspects. And believe me, when I walk and look downtown, there are some very unique aspects. Those descriptors of and there was, I don't know, 50 of them probably.
Yeah,
I don't know how many were there in there, you know. But I was schooled in architecture and schooled in landscape architecture, and a lot of those I don't know what they are. One of the reasons that I suggested that those get axed out is because without a definition of each of those, I don't know how you could really say this is a colonnade and this is not, and it just becomes just massive. What is important, I think, is the context of your downtown. Where is this fitting? What's it next to? What's across the street? How are you going to fit and make us assured that what you're doing fits with that, regardless of if it's a pilast or a colonnade? That's not important. What's going to be important is because you guys are going to be able to look at those renderings in the end and say, yeah, that fits, and yeah, that's going to add some economic value to our downtown. Yes, that is going to promote the pedestrian corridor, the pedestrian access. That is going to promote multi-use. Those are the pieces that are built into the purpose statement. So yeah, those pieces are X'd out because I thought they were very confusing, and maybe you guys were used to them, but. So that's kind of my 2 cents on why that happened or why our recommendation is for that.
So is that where you have said it's less prescriptive? The old style was kind of prescriptive by having those terms and this
Yes.
style of architecture is allowed, but that isn't.
Yes, that's how I viewed it was very prescriptive that, you know, you needed to identify, you know, kind of the period of architecture that you're dealing with, and then the components of that, and then figure out how you're going to make that fit, you know, or not. I guess there wasn't really anything in there that said that it needed to fit. It was kind of a checklist of if you did this, kind of expected that you would get an approval.
Okay, interesting. Thank you.
So I just want to clarify, we're looking to either approve this tonight or decide to table it until the future, is that right? No.
I think that we have enough questions here tonight that we're just going to postpone the
Okay.
vote on this. We'll
All
take
right.
it up.
And so I just want to be clear on mine. With respect, under the appeal, it is just written towards the applicant, so I would like something added in there regarding neighbor or business owner within a certain number of feet. Just some sort of additional process, because that is not written in this portion of this zoning anyways.
So we will circulate some language for council consideration.
Thank you.
Okay, so Bob, also with respect to 118, I wanted the Plan Commission to hear this as well. So seeing as how we're bringing this ordinance back anyway, why don't we hold off on 118, do that at the next Plan Commission? Oh, that's tomorrow,
No,
isn't it?
no.
Oh, it's mid-month. So it'd be the first Tuesday of October.
Yeah, I think you threw me for a loop last time, and I was thinking I had to be here tomorrow, and then it wasn't.
Yeah, you know, I did
I'm
that.
driving home thinking,
You're right.
Not
Yeah.
on my
It took
calendar.
you that long?
Well, I haven't seen you since then, you know?
No, I did say that. I apologize for that. Although I certainly would have come here to meet with you. But yeah, we'll hold off until the Plan Commission meeting, start there with 118, and then come back when we bring this whole package back. You can talk to the council about 118
Yeah.
also.
So along those lines.
Oh, and in the meantime, could you Could you send us the information you have on 118?
That's exactly what I said. In the meantime, I will just send you my PowerPoint. And there's also a 1.5 page kind of narrative of the history of NR 118 that the PowerPoint is based on. And then the PowerPoint goes a step further than the narrative. It ties in what you guys are talking about, the overlay. So the underlying zoning is there. There's the overlay district. So, and that's there. And then NR 118. And so there are some times when the underlying zoning, NR 118, and the overlay are all in play. And there's other places. And there's a map in here that I'm showing you that will show that, and we can speak about that.
So when I talk about the history, wanting to know the history of 118, I want to know the genesis of it. I
Yes.
want to know the groups that were involved in promoting it. I want to know the rationale between Osceola and halfway through Prescott and things like that.
I'll send you, Mr. Mayor, I'll send you what I have, and then we'll have a conversation.
Okay.
Mine isn't quite that detailed, but if that's the stuff that you're looking for,
What's that,
we can
tomorrow
certainly
night?
find that.
There is no plan commission meeting tomorrow.
No,
night.
but he and I are going to have a conversation. But nobody else will be here. It'll just be you and me. All right, so anything else, Bob?
Not from me, unless you have other questions.
Okay,
I think it was very helpful, Bob.
yeah, thank you.
Thank you. Thank
So
you
if
very
you don't
much.
mind, I'm probably not going to stay for the rest of the meeting.
Sure,
I understand.
thank you.
Is there a motion to postpone?
No, just, yeah. All right, ordinance 13-23, amendment to chapter 235-3 parking regulations during snow event.
Chief?
Chief?
Thank you. Good evening. So this change basically started with a conversation between the fire chief, myself, and Public Works Director. The current ordinance that adopted the snow event language back in 2010, 2011-ish, somewhere in there, quite frankly doesn't work. It allows for a violation to be made, and then the car sits there for 48 hours before we can get it out of there, which does nothing to the process of allowing Public Works to clear the streets. So we came together to decide what we could do as staff to try and figure out a better solution. Another component of this is going to be marking certain streets in the city as one-side parking in the wintertime. But that's coming at a later date. We wanted to try and get this one implemented before the snow starts flying so that we can have a little bit more positive effect in this coming winter. The changes for, if you don't know, the change basically just allows us to tow violator vehicles immediately instead of having to fall back on a 24-hour parking ordinance, which would require a citation for the snow event, but then a 24-hour warning placard. 24 hours later, if the car is still there, then we give it a ticket for the 24-hour violation, and then we could tow it. This basically, in a snow event, would allow us to tow the vehicle immediately to get it off the road so that it can be
So
cleaned.
Chief, let me ask real quick, I guess I didn't think of this while I was reading through there. Who tows?
Oh, yeah, sure. Sorry.
Bob, you're still here?
Yeah. Looking for that, NR 118.
I'll find it later. I'm sorry. I have technical issues every time I come here.
Hey,
I apologize.
So who, no problem, Bob. Who does the towing? Are we under contract with the towing company?
Yes and no, not really. We usually just call Jerry's Towing
Okay.
to do our tows because they have drivers on
Right,
staff
and
24
so,
hours a day.
and that's fine. I mean, the reason I ask this is because I can't remember, I'm pretty sure it was Minneapolis that just had a contract with towing companies and they just came and, I mean, that's how they made money. They just went through the streets and picked up cars.
Yep,
without
no,
any
all
warning.
tows are initiated by the police department
Okay,
or parking.
all right, thanks.
I'll move to suspend the rules.
Second.
Got a motion and a second to suspend the rules, roll call?
Morissette?
Yes.
Wakefield?
Yes.
Knutson?
Yes.
Kennedy?
yes,
Brooke?
Yes.
Hall?
Yes.
Motion's approved, rules are suspended.
Move to adopt ordinance
235-3.
235-3, or ordinance 13-23.
a second.
Got a motion second to approve. Any discussion? All those in favor?
Aye.
Opposed? Motion's approved. Thanks, Chief. So the only thing I have is that we have our Celebrate Hudson Community Booyah coming up Saturday, September 30th at White Camp Park. Hope to see everybody there. Anybody want to volunteer? I know a number of people already have, but love to see people volunteer. And this, of course, is put on by the Golden Rule Initiative in furtherance of civility and respect in our community. And it is from 2 to 6. It's for everybody, family friendly. We got a petting zoo. Our Hudson ambassadors will be there with face painting and tattoos and a number of different things, games, party stuff. So I hope to see everybody there. Thanks, Bob. You're invited too.
I'm always thank you.
Move to adjourn?
Second.
Got a motion second to adjourn. All those in favor?
Aye.
Opposed? Motion's approved. We stand adjourned. Thanks, everybody.
Thanks.
Thanks, Mike.
Have a good night, everybody.